Hey, David, how are you?
Hey man, how's it going?
Good, good, good. Sorry about the delay there. I was jumping off another call and then, sort of uh, trying to work my way through Discord here.
No
But yeah,
worries. Thanks so
great.
much for joining.
Yeah, of course.
I also started this a little late, so that's on me too.
No, all good, man. That's the nature of things these days, right? So yeah, I saw your email come through this morning to sort of run through things. I guess, do you want to set the stage here a bit and then we can sort of, jump into questions or, how do you want to run this?
Yeah, definitely. Um, let's maybe start with an introduction. This
Cool.
is your first time speaking to the DAO. So first, let me welcome you to the Discord. So Mark is an attorney in the DeFi space and the founder of 1121 Law. He and I were introduced through a mutual connection last year, and it's been a pleasure working closely with him as Ren-based Labs' counsel over the past couple of months. Based on my time working with him, I know that he's someone who knows how Ren DAO can set itself up to make the most of this sort of growing up opportunity. And that's why I didn't hesitate to reach out to him. So we're all grateful that he's joining us today. So Mark, thank you for taking the time.
Yeah, absolutely. I'm happy to give sort of a little bit further background, just sort of on the crypto side. So I've
Yeah.
been sort of in sort of crypto, quote unquote, if you will, since 2018. I was at a firm out of San Francisco called Atrium, which was a half startup, half law firm, and we were fortunate enough to represent a bunch of the early DeFi folks. Uniswap, DYDX, Dharma, whether they're DeFi or not is another question. But and then just a number of top crypto projects, Tendermint and Polygon or Matic, and so sort of cut my teeth 2018, 2019, 2020 at Atrium. If anybody's familiar with Atrium, which you may or may not be, but it ended up failing in March of 2020. So at that point, I sort of spun off my own shop here, which is the 1121 Law. Have been running that shit coming up on 3 years now. But we're basically 100% crypto, represent a number of layer ones, a number of layer twos, heavy on the DeFi side, got a couple of borrow and lend, some under collateralized or off chain collateralized folks, a large layer one, and then just sort of a smattering of other folks, a DEX, and then whatever, some random other NFT stuff and stuff like that. But basically, 100% crypto, and it's been that way since 2018. I only say that because I think there's some lawyers who are like, hey, they got into crypto last year and they don't know the first goddamn thing. I'm certainly not an expert on the technology, but I at least have a MetaMask and a Phantom and can interact with some of this stuff, which I feel like is necessary to actually advise. But I've have advised a number of clients on the creation of offshore entities, whether it be Swiss, Cayman, or Panama. And so I'm familiar with that structure, familiar with the offshore, the more recent approach to going to Guernsey, and have advised a number of clients on pros, cons, appropriate structuring, ways to mitigate risk. I mean, I think the reality of it is there's no perfect approach. There's good things and bad things about every choice, but have certainly it helped other people think through that process, right? So yeah, that's me.
That's great. So on formatting, I'd like to hit the ground running on a discussion
For
that
sure.
ties in some questions that we've gotten from the AMA channel, and then
Yep.
we can invite people up to the stage to ask questions directly. Just a quick housekeeping note. Listeners can get caught up on the subject by referring to the Foundation Setup channel if you haven't already, and you can ask and upvote questions during the call in the RawZack AMA channel. So to get into it, for a bit of context, there are three immediate functions I think that the DAO sort of needs to have handled in a legally compliant way.
And
Number
when you
one,
say the DAO, like the DAO does not there's no sort of legal wrapper, quote unquote, yet for the DAO. That is that I believe that's accurate, or am I wrong there?
That's correct. And I should make a distinction between the Ren community and the Ren DAO. The Ren DAO is a collection of node operators that have voting power in governance.
Okay.
The Ren community is a bit broader, you don't have to be a node operator or even own Ren to be in the community. That's open to everybody.
So it's just basically a Discord channel.
The community, yeah.
Yeah, okay, for sure. But then the validators or the node operators have sort of a heightened governance function, right?
Correct.
And this is similar to like Cosmos, where I think the validators are defaulted to have the governance rights for most of the tokens. Is that accurate?
Yeah, so the way we have voting power set up is that your voting power is the square root of the number. I don't mean to make this more complicated.
Hey man, chill out. I'm just kidding.
It's basically how long you've been operating the nodes that you have.
Okay, got it. Yeah. So you're sort of rewarding people who are long-term node operators. The idea being that they're sort of more in line with the long-term success. Yeah, all the rest of it. So no, that totally makes sense.
Yeah, but in a way that allows more recent operators to kind of catch up over time.
For sure. Yeah, you don't want an old guard to be the only people who are
right.
Yeah, exactly.
Exactly. So going back to those three functions, number one is minting the new treasury, taking custody of it, managing it.
Yep.
Number two is funding protocol development on an ongoing basis.
Yep.
By issuing grants to contributors, other working groups, potentially other entities that the DAO might establish. And number three, to own the protocol IP.
Yep.
So it seems like...
Is there closed source IP there?
So most of the repos for Ren 1.0 are open source. There are a few that are still closed source, but all of the repos that will make up Ren 2.0 will be fully open source. Okay.
Yeah, just to get a sense of the IP. I mean, it's generally, there's some question as to what IP is relevant, and do you have trademarks and all the rest of it, or is it actually like code? But I mean, that's something to be sort of figured out down the road. So the initial issuance was done just via sort of like an ICO back in the day approach with no sort of legal entity, right?
I'm not sure if that's fully correct. So the Ren team that existed before they were formerly known as Ren Labs, it did have an operating structure. If I'm not mistaken, the ICO was conducted by them under that structure.
Got it. Okay.
And I want to say that was in late 2017 or early 2018.
Yeah, got it. That makes sense. But I guess, as we currently sit, there's not sort of like a legal wrapper. Like if the DAO needs to hire somebody, who's the counterparty for that? Is there like a specific entity, or is it just like Ren DAO, and there's not like, we're not pointing to a specific legal entity, we're pointing to sort of this quote unquote unincorporated partnership that exists?
The latter.
Okay, yeah, you should probably think about changing that, but I guess that's why we're chatting and why you're chatting with other folks, right?
Exactly. And I think, the recent events around Alameda were kind of an opportunity for the DAO to step in and take the reins on a lot of this operational governance and, funding and stuff like that. So the DAO has a big opportunity to set things up in the right way.
For sure.
And, we want to make sure we do it correctly.
Absolutely. That totally makes sense.
So it seems like at a minimum, most of the structures that we'll probably talk about today are suitable enough for handling all these functions at a minimum, but there are all these other considerations that have more to do with preference than requirement, right? Yeah. And so I think it'd be worth maybe framing this discussion around those considerations in the context of different structures and jurisdictions.
For sure.
And this isn't really intended to be comprehensive, just a high enough level to cover the bases and for the DAO to make a sufficiently informed decision. So maybe you can start off by just talking about why limited liability is so important in the context of DAOs.
Yeah, I mean, it's sort of something that why we create entities on any level is so we don't have sort of personal liability. And so if you don't have sort of a legal wrapper operating around this DAO, sort of by default, and this honestly hasn't been tested in court, but I think this is durable, is that if you don't have a legal entity, you end up being what's basically an unincorporated partnership. And I always use the example of a lemonade stand. If you and I went out and started a lemonade stand, we're not going to file with the state. We don't have an LLC. We're just two people coming together for the purpose of engaging in business. And so by default, we become an unincorporated partnership. What does that mean? That means our activities in that unincorporated partnership could subject us to personal liability. If you grab cyanide instead of sugar to mix in with the lemonade and somebody dies, we both could be held personally liable for that, right? And if we had a legal entity, there's some question, but the chances that we'd be, and maybe the cyanide one isn't the best example, but if we had a legal entity, we're generally going to be protected from a personal perspective, from unlimited liability. I'm not going to be personally liable for actions that the partnership takes, or I'm not going to be held personally liable for the actions that you may take. And so that's sort of the issue without having a legal wrapper, is that I become personally liable for any actions that the unincorporated partnership may take, and personally liable for any of the actions that any of the other partners may take in furtherance of the partnership. And so, when you have sort of a large, broad, like unincorporated partnership that's been created via a DAO, you get into a situation where you're subjecting yourself to significant liability. Maybe, and some people use this approach of, well, I'm not participating in my personal capacity, I'm participating as this entity. And so that may provide some liability protection, but that's a hard thing to maintain, because then you sort of have to always put on your company hat when you're participating in the DAO. Hey, this is not me, David, this is David Labs Inc. that's participating, and sort of like clearly delineate that. So if something were to go wrong, someone would know, hey, we can't bring an action against David, we have to bring it against this his entity, right? So it's generally sort of a foundational thing that as a lawyer in the space you look to have just to protect folks. And I recognize, there is the idea that there's some point of centralization, right? So you have to file or have some sort of an agreement between the parties to have this limited liability protection. And so, I guess I'll pause there real quickly if anybody has any questions, and I'm going to try to segue into talking about foundations and special purpose trusts. But I realize I'm sort of probably throwing a lot of crap at you guys, so happy to touch back on anything else.
Yeah, I think it'd be helpful to work up from these kinds of considerations that need to be made, and then to try to find a suitable legal entity that fits the DAO's preference for such a structure. On the topic of liability, one interesting theme related to liability is whether to have a representative structure with a limited number of trustees or board members, or to wrap the DAO in such a way that all members can act as trustees. So if being a trustee or a board member were effectively permissionless, where any trustee could enter into a contract on behalf of the trust, would that create an attack vector and put the trust's assets at risk?
Yeah, I think it's a good question, and it sort of gets to this issue is are there active participants and passive participants, or in the same partnership context, is there a general partner and limited partners? And generally, and this hasn't necessarily been tested, I don't think that should put the trust itself or any sort of foundation at risk, or the assets at risk per se. But you definitely create a situation where if people are participating to a greater degree, the chances that, they're subject to some liability for their actions are greater. But to be honest, like, we're dealing in a world where we're multi-jurisdictional and we're new, right? And so this is not something that's been tested in a court. And so, as lawyers in the space, what we try to do is draw parallels to existing things that we know. But there's not a perfect parallel for that. And I think the best one is this general partner, limited partner concept, which I think somewhat describes what you're talking about, and doesn't really wouldn't impact the assets of the partnership or the trust necessarily, but could impact the liability of certain actors, sort of having a heightened role as an active member as opposed to being a passive member. But again, those distinctions are hard to draw in the sense, like, if you had, someone out of the U.S. participating in a special purpose trust, like, what jurisdictional hook is there to the U.S. if there was a case brought in the U.S. where the U.S. have jurisdiction based on some member's activity, like, it becomes really hard to sort of game plan all the way through exactly what that would look like, because we don't have any precedent for it, and because we're dealing in this sort of like borderless world. So I don't know, did that answer your question?
Yeah, it seems like you agree that, generally speaking, and correct me if I'm wrong, that the DAO would be more alleviated from taking actions that could result in liability for them under a more representative model, in the spirit of that uncertainty, right? Since we're still figuring things out.
Absolutely. And I mean, the concern would be, and again, this is like, I'm not saying this for sure, but I think the thought process would be is if you have sort of a non-representative, I don't know if non-representative, but if you have sort of an elected group or some centralized group who are making the decisions, someone could challenge one of those decisions, say, hey, you made the wrong choice. You did X, you should have done Y. We were harmed because you did Y instead of X. You acted unreasonably or negligently, and so therefore you're sort of liable for those actions. I think it's an unlikely outcome, but if you have a situation where it's more representative, then there's not that centralized group that you could point to and say, hey, you fucked up and your fuck up harmed me, excuse my language. And so I think from that perspective, having that sort of more flat governance structure puts everyone in a position. And you all are probably not super familiar with corporate law, but generally the idea from a corporate perspective is if there's big matters that have to be decided upon, and Delaware corporate law says this specifically, the shareholder should vote on that, as opposed to just the board approving it, right? And so it's sort of this same parallel that I think you're talking about here. And from a corporate perspective, we love it when the shareholders approve it, because then the shareholders can't come back and say, well, why did you do that? You fucked up and I was harmed. It's like, no, dude, you approved that. So, like, you can't say that you were not okay with that. And so I think that, that's sort of the way I think about these issues. And again, I'm not sure I answered your question, but I'm trying here.
That's a good segue into legal rights. So a big theme to me is that a Guernsey trust sounds like a legal vehicle for the DAO itself, which has actual legal rights over the trust, like appointing trustees and the enforcer, adding, removing purposes from the trust, terminating the trust, so on. Would the DAO have any legal rights over a foundation in another jurisdiction like Switzerland, Panama, Cayman?
Yeah. And I mean, it's the same thing. What you're trying to do is, it's the same issue that exists for all of them, really. And what you're trying to do is you have this legal entity that exists on paper, and you have this DAO which exists sort of basically on chain. And so you try to tie the two together. And so I don't think there's any real difference, because if you're doing a Cayman, Swiss, Panama foundation, you're going to put something in the foundational docs that basically point to this smart contract and say, hey, look these are the people who are controlling it. And you basically do the same thing in a special purpose trust. And really what you're trying to do is strengthen the ties. And the approach that I like, because I think it's just intuitive, although again, no court has ever said that this is necessary, is you do it sort of both ways. You have not only the foundation of the special purpose trust say, hey, look at this DAO, they're going to manage. But then you also have the DAO on the other hand saying, hey, look at this special purpose trust, look at this foundation. This is the legal wrapper, and we're tying the two together as much as we can when we're trying to tie this digital on-chain activity to this basically paper in sort of a legal entity. But I don't think there's a benefit to Guernsey or any of the other ones. Again, we're dealing with, I could be wrong. I could be wrong there, but that's generally how I think a lot of the top crypto practitioners are thinking about it. But it hasn't been tested in court, so a lot of this is just me talking, right? I think what I'm saying is accurate and in line and reasonable and been thought through. But I can't. If you told me to point to a case, I can't do that because we just don't have that yet.
How should the DAO properly vet appointees, whether they're board members of a foundation or trustees or the enforcer in a trust? For example, should trustees in the trust structure be required to prove residence in a country that has an extradition treaty with Guernsey, or non-US residents for tax purposes? Can you maybe go into that?
Yeah, it's a really, really good question. I mean, I think sort of from an outset, the way I look at this is like there will probably, and particularly on the foundation side, which is more common, the special purpose trust is a little bit newer, but there's going to be people who have sort of legal authority via either a special purpose trust or a foundation. But do they have any authority when it comes to actual on-chain activity, right? And so that's sort of the first thing that I start to look at, which is, hey, if you have, and a lot of times in Swiss, Panama, Cayman, you have sort of like nominee directors, which is basically somebody you hire to be a director, and you pay them like anywhere from 10 to 30 grand a year, and they're sort of the person signing all the documents for the foundation. That person could sign in a document that says, hey, all the assets belong to me. I don't think they would do so, but if they did, it's just a piece of paper, and they have no ability to go on chain and actually affect that. And so I think if you're creating a situation where the trustees also have authority on chain, then we want to be smart about how we're thinking through that issue. Are they doxxed? Are they not doxxed? Where do they live? Is there some sort of extradition? What checks and balances do we have from an operational on-chain perspective to ensure that we're not sort of giving someone too much authority, right? Because we're dealing in a weird world where people are pseudonymous and we're not sure who they are, where they are, and so trying to sort of hold someone accountable for their actions can be difficult. And so I think we should look at what sort of power do they have and what risk do they have. If they all of a sudden become a bad actor, then what does that look like? And I think it's really around this idea of like on-chain and off-chain. Could they do something to actually distribute a bunch of the treasury funds out to their own wallet? If they can do that, then I think we should, whether they need to be doxxed or they need to be from a certain jurisdiction that has extradition is something we'd want to think through for sure. But those are the sorts of considerations that I look at, which is like, what true risk exists here. Again, if it's just someone who sits as a nominee director, they can go sign any sort of board consents or do whatever the hell they want. They have no authority or ability to manage anything on chain. So if you go rogue, all you have is a piece of paper. And, what happens then is another question. But I haven't had that happen yet, for sure.
So in the context of acting off-chain, is it the case that someone may be able to enter into a contract, and then if the obligations of that contract are not met, then the assets under the trust's control would be put at risk?
That's a good question.
In that sense, isn't there a sense of needing to be either doxxed or having a high standard for appointees, even in an off-chain capacity?
Absolutely, I think so. But what we generally would want to do is have some sort of DAO vote that grants them their authority, right? Because somebody who's just a passive participant could go sign some contract, but is that actually legally binding to the foundation or to the special purpose trust? Well, are they acting as an agent for the DAO or not? And that sort of becomes a question there, and that's something we want to think through as far as like who has the authority to bind us in what regards, and what sort of authority do they have? And there can be express authority where we basically have taken an action, and that's where probably I prefer that people land, which is, hey, there's actually like a vote that's happened that's given XYZ person the ability to engage in XYZ contracts. I think there's some risk there, yes, and I think to me, it's not the same sort of risk as someone who could just, push a bunch of assets to themselves on chain. But yeah, there's some risk there, and I guess it becomes a question for the DAO as far as like what sort of controls or checks or balances do we want on those people? Because yeah, they could sign some wonky, crazy contract, but I think that what I would argue is that the DAO or the foundation, the special purpose trust, would argue that hey, that was outside of their authority, and yeah, they signed this thing, but this thing really didn't represent us, and they sort of went rogue on us, so therefore we're not liable, and we're not legally bound, and this contract is void ab initio, void from the beginning. But yeah, I mean, I think you're thinking along the right ways, that there's certainly some liability there, and we want to think through who we're granting sort of authority to act as an agent.
So in the trust structure, trustees retain control over the day-to-day decisions regarding the use of funds. I'm just reading that from the DYDX article.
Yep.
So is it the case that, if a trustee were not acting in the best interests of the trust, that would be considered a breach of their fiduciary duty?
Exactly. Yeah.
But that kind of seems to be like an arbitrary thing, where if we're thinking about whether a trustee that went rogue was or was not acting in the best interests of the trust, they're still legally able to retain control over the day-to-day decisions of the trust, right? So I'm thinking about like how to strike a balance between those two. There seems to be a little bit of a tension there.
And I think there is, right? And it's just one of those situations. I mean, there's a number, and at least Delaware and most other jurisdictions have sort of enumerated fiduciary duties. And the big duties you think about are duty of care and duty of loyalty. Duty of care basically means, are you being reasonable? Are you doing what another reasonable person in your circumstance would do? And then the duty of loyalty is, hey, did you put your interest above the interest of the trust or the foundation or the company? And so, but those things, there's this whole spectrum of facts and circumstances under both of those. And some, depending on the jurisdiction, have found, hey, if you do X, Y, Z, that is a breach. So it becomes this issue of like, yeah, what's a breach, what's not a breach, and it becomes difficult. And while that, if there is some challenge, they would still retain the authority as the trustee in the interim. So it certainly could get tricky, and I think that's why you have to do your best to pick trustees that can be trusted, for lack of a better word, because to sort of actually bring an action for breach of fiduciary duties to a trustee, again, it's not an easy thing. It's not going to be quick. It's going to be messy. What happens in the interim is just going to be a bad situation. And, unfortunately, there's no sort of like full legal protection there. And maybe there's a way to remove them via, token holders, which is probably where we should end up. And that would be similar to shareholders removing a board member in sort of the traditional corporate context. And so if a board member is acting in a way, and maybe that board member is also an officer, that the shareholders get together and say, hey, no, we're not okay with this. We're going to vote you out. Whether you cause some harm to the company by your breach is a separate issue for a court. But in the interim, we're going to revoke your status and basically, vote you out, if you will. And that's sort of the same structure here.
That's a good segue into accountability. So in a Guernsey trust, we know that the enforcer is able to bring legal action against trustees for violating their fiduciary duty, even if it might be messy. But if a trustee were unwilling to show up in a Guernsey court, let's say, does the DAO need to trust Guernsey's extradition process and extradition treaties with other countries to hold trustees accountable and for the trust structure to work?
Yeah, I mean, the question would be is, where does this other person sit? Did they do something in that other jurisdiction which would give you a hook outside of Guernsey? that's where I'd want to fall on it. I mean, that's a difficult analysis, but like instead of going to Guernsey, if this person was U.S. and had engaged in activity that is potentially tortious under U.S. law, why go to Guernsey? Bring it to Delaware court. I mean, there's going to be a question whether Delaware court or any court for that matter, California, New York, wherever we may be, has jurisdiction over that activity and that individual. But I wouldn't necessarily look to Guernsey and relying on these extradition issues. I mean, maybe, but that would be it. It's not something I would feel super comfortable with. And part of that is like, I'm not familiar at all really with, the extradition process in Guernsey and, the history of it. When they seek to extradite someone, do the companies or countries respect that? If somebody's broken a law, and you can almost see with SBF now, like, Bermuda and same with the bankruptcy, like, which country has sort of the superior right to have jurisdiction over this person. And so that idea of like trying to game out whether someone could be extradited to Guernsey, and it would also have to be a criminal thing. Generally, if it was civil, they're not going to extradite you because you did something that maybe harmed somebody, because you acted negligently or whatnot. Yeah, certainly if it was fraud, embezzlement, criminal activity, then yeah, it's more likely. But it's a hard thing to game out. If someone steals $5, I'll guarantee you the Guernsey extradition folks aren't going to give a shit about $5. 5 million, maybe. But that's a hard thing to look at. And what I would look at generally is making sure that, I hate to go there, but making sure these people are doxxed so that we can hold them accountable if necessary. And maybe they don't need to be doxxed to the entire community by any means, but they need to be doxxed in some regard. Because I wouldn't want to go to Guernsey. I'd want to, if somebody ran away with a bunch of trust assets, I'd say let's go to the DOJ, right? Like, the U.S. Department of Justice is a lot more powerful than some Guernsey criminal court, right? So does that answer your question?
Yeah, so the reason why I asked that question is because I was reading through the DYDX Grants Trust Agreement. There's a clause, 7.5, which says that all disputes concerning this settlement arising in the course of its administration shall be heard by the courts of the island of Guernsey, to whose exclusive jurisdiction the parties to this settlement, so on and so forth. So if there's a negligent or criminal action taken by a trustee on behalf, or maybe not on behalf of the trust, if that action is taken in the U.S., does the U.S. have jurisdiction?
Yeah, the DOJ would
action against that. Despite
if someone stole $5 million and the DOJ was interested in pursuing it, they're going to say, I don't give a shit what this piece of paper says. This person was in the U.S. and engaged in wire fraud, mail fraud, a number of other things. They're not like, they're not going to be. If it's a civil issue and it's a breach, or it's a breach of fiduciary duty or some other sort of civil issue, you did X and I was harmed financially, but it wasn't sort of a criminal action. Then yeah, Guernsey would have the ability. But in a civil context like that, extradition becomes irrelevant because, again, I'm not a Guernsey expert, but I don't think they're extraditing anybody for civil issues. I can almost guarantee that. I don't know that for certain, but my gut tells me yes. And so we do have these other sort of levers that if someone were to engage in criminal activity, and you're seeing this on a lot of different fronts, and you can see it in the OpenSea case. If you're engaged in some sort of fraud and you have any nexus to the U.S., the wire fraud and mail fraud statutes in the U.S. are extremely broad. And so that gives the DOJ significant authority. If you've done anything using the mail or the internet to engage in any sort of fraud, or have sent a wire or used the banking system at all and engaged in any sort of fraud, they can tag you. And I think it's a minimum of 10 years, maybe 20, and they can stack those on top of each other. And so you're like, if someone is engaged in some criminal activity and they have a nexus to the U.S. and the DOJ is interested in bringing that case, like, they yield an extremely heavy hammer because, yeah.
So let's maybe zoom in on civil cases then.
Yeah, absolutely.
So in Guernsey, if a civil case were brought, um, so I guess I'm wondering, would civil cases vary based on jurisdiction? Like, do they work differently? Like, is a trustee more liable for a civil case or more likely to be prosecuted, I should say, in another jurisdiction like Switzerland or Panama compared to Guernsey? Or do they all have the same issue where as long as the trustee doesn't show up, they're probably not going to get extradited?
Yeah, I mean, again, it's hard for me to look across all those jurisdictions and say X, Y, and Z. But if it's a civil matter, extradition is almost certainly not going to exist, right? If it's a criminal matter, so someone broke some Guernsey law, then yeah, Guernsey may have an interest to a degree where they're going to seek to extradite, and same with Swiss, and same with Cayman, and same with Panama. To me, probably Switzerland is going to be the most sort of robust from an enforcement standpoint over like a Cayman or a Guernsey, and then probably Panama at the bottom. And really, what this is, if there was some harm or fraud, any of these local jurisdictions, they want to secure their position as being a safe and secure and legally durable offshore or non-traditional financial center. And so if there's some harm that was brought, it's going to be in their interest to sort of make sure that that's remedied, right? But it's really hard to sort of to think through that from a civil perspective. And certainly I'm not a lawyer in any of those jurisdictions, so keep that in mind.
Sure. So one advantage of Guernsey that we know of is that it's just a private written agreement between trustees and the enforcer.
Sure.
With legal rights that are retained by the DAO. That written agreement doesn't require any government approval in Guernsey. So those roles, the trustees and the enforcer roles, can be wholly appointed by the DAO itself.
Correct.
Conversely, other jurisdictions do require approval, and potentially local directors or a trust company and so on.
Yeah.
So should the DAO consider government authorization and compliance to be an advantage or a disadvantage?
I mean, I almost see it as a disadvantage just because cost and bureaucracy. There's no real advantage that, like, hey, we had to file in Cayman as opposed to us not having to file in Guernsey. I mean, certainly the Guernsey Special Purpose Trust hasn't been litigated probably as much as the Cayman Foundation or a Swiss Foundation. But, to me, I'm hard to see, it's hard to see a true benefit to having this sort of like filing with the government, right? In Guernsey, we have this idea of sort of this separate legal entity that can be existed by these parties coming together and signing this internal contract. And that looks similar to, an LLC here in the States. Yeah, you need to file on an LLC, but after you file, you could have no operating agreement, but generally you should have an operating agreement which dictates how that LLC is run. And so it's sort of a parallel to, how the special purpose trust operates, in the sense it's a bunch of people who are coming together and saying, hey, we're going to operate in XYZ way. So I guess the answer to the question is, like, I don't see, there has not been anything that we've seen to date that demonstrates that there's a true benefit to having some sort of government filing and, registered agent and registered director in any of these jurisdictions. Like, I put the typical lawyer caveat out there. Maybe in some point in the future there's something that happens, but I'm not seeing it from the people that I represent. And half of my job is staying close to the other top practitioners in the space who represent all the top projects, to see what the hell everyone else is doing, right? Because part of this is best practices. We're all sort of making it up. And so I want to know what the other top people are doing, what they're thinking. And so we sort of like, there's sort of like a crypto legal bar of, like, a lot of the top people have been doing it for a while and they sort of know each other from one way or another. And so I haven't sort of seen, no one's out there saying that, this is necessarily the way to go, where we have a government filing, and so we have to go to Cayman. I haven't seen anybody make that assertion in a way that seems, sort of durable to me.
So the DAO needs to start funding development and contributors ASAP. Can you maybe just walk us through the implications of setup time across different jurisdictions?
Yeah, Panama, you can do it in a couple of weeks for like 12 grand. Cayman is going to take you a couple of months. Shit, it used to be 30. Now I'm seeing more like 50 or 60. Some of it depends on what you're doing. Switzerland is going to be.
Right, just to clarify, that's the last jurisdiction was Panama, you said?
Cayman.
Cayman.
So, yeah, and I can put this in an email to you, and we can circulate this around just for people to sort of get a look at it. And that may be a good follow up, is to like, and we've done this before for other people, sort of like outline the options, right? And so yeah, Panama, cheap, quick, 12 grand, roughly, maybe 13 or 14, and a couple $1,000 annually, and you can do it in 2 weeks. Cayman is going to be probably 2 months at best. And will probably be 50 or north of there. And there will be at least 5 grand of annual fees. Switzerland, I haven't seen anybody do it in less than 3 or 4 months, and it's probably going to be more than that. And it's probably going to run you 100 grand. Guernsey, we would want someone who specializes in the Guernsey Trust, but there are no filing fees. And so part of it would depend on how efficient we could work with a Guernsey council to create these trust documents. So it's hard to say. It could be, Guernsey could be 10 grand, but if we, sort of like make this super complicated and are waffling back and forth on how we do things, it could be 50 grand. So there's more variability on that front because, it really comes down to these internal documents that we're signing. And if we know how this thing is going to be run and operated, and we just need to paper that, it's not so bad, right? But if it's, hey, we're figuring out how we want to do this, and we want this structure, then no, we want that structure, it's going to become more expensive, and that sort of goes for the rest of them as well, but more specifically in Guernsey.
So there definitely are some costs in setting up a Guernsey trust, despite not requiring government authorization?
Because we're going to want someone in Guernsey who's done this before. And there's a couple of firms that do this sort of work. And, they're going to at least be 10 grand. And then part of it is like, how well do we manage that person? How well have we thought things through on our end? And what else are we using them for? If we are sort of structuring contracts with consultants and development and the IP on our end as opposed to on their end, then it will be sort of on the lower end. And it sort of depends on how we're managing this, right? Are we going to them where we basically have everything decided and we're just asking them to paper it and we're sort of handling a lot of the other agreements? Then we can do that pretty cheaply. But if we're going to them and it's a holistic review, then as you know, I sort of generally work on a monthly flat fee as almost like outside general counsel, so there aren't those issues. But generally legal bills can run sideways on you, right? And so it depends on like how well they're managed, and that's one thing that I do for folks is like, hey, let's make sure we're not going to Guernsey and getting slapped with some massive legal bill because we don't know what we're asking for and we don't know what we want. And the same exists. I mean, I love a lot of the Cayman lawyers and I'm close with them, but you've got to put those people inside a box or they're just like, they're going to sell you shit you don't need. They're going to, and maybe you don't need it. Don't need is a strong word, but, there will certainly be things that aren't necessary that they offer or suggest. And being able to think through, is this really necessary or is this really not? A lot of that is going to dictate costs. So any of the numbers I just told you are sort of up for revision based on some of these other things. Or, do we need an AML policy and an AML person or compliance officer? Probably not. But if you go and you have a Cayman foundation and a BVI sub, they're going to try to sell you on that. And in some regards, it's necessary and totally appropriate. In other regards, it's not, right? So it's sort of just managing that process and making sure you don't let the lawyers sort of like run you into a massive bill, and recognizing I'm also a lawyer. But did that answer your question?
I think so. If not, we can always follow up on that.
Yeah, for sure. We can't answer it, right?
To branch off on costs, with respect to tax and reporting obligations, so Guernsey appears to have no tax on the transfer or exchange of tokens, as well as no tax filing or reporting obligations. Would a foundation incur meaningful taxes or compliance overhead in a Switzerland or other jurisdiction?
No, generally not. I mean, a lot of these jurisdictions have no corporate tax. The issue becomes, and this is an issue for any of these projects, and this is the issue that I'm sort of most mindful of on the tax perspective, is this entity somehow subject to U.S. taxes? Does it become a U.S. tax-based payer based on the facts and circumstances of how it's operating? And that's really going to be sort of the biggest issue for us, is making sure that this is set up in a way where, I mean, because you can imagine it, like David, let's say you and I would go and create a BVI or company and we run everything through there and we're managing it completely from the US. Well, the IRS says, no, you have this offshore entity, but you're managing it from the US. For all intents and purposes, it might as well be a US company. And even that's a BVI or a special purpose trust or whatever it is, or a foundation for that matter, you're operating in a way where you're subjected to U.S. taxes. And so that sort of becomes the bigger issue then, because a lot of these offshore jurisdictions have this structure where they have no corporate tax. So we're not necessarily worried about the local taxes. We're worried about getting pulled into the U.S. tax net. And, that's the biggest concern.
And so is the way to mitigate that to make sure that a majority of trustees are non-U.S.?
Yeah, that's basically right. And really, it comes down to this issue. Where are the decisions being made, right? And if the decisions are coming from the U.S., but there is a concept on sort of the tax side as well as, hey, if there's a sufficiently decentralized governance mechanism, and say there's a million people who vote and 51% of them are U.S., well, under that circumstance, and we haven't seen that fact pattern, but from what I understand from the tax folks, and I work with some of the top tax people on this stuff, is like that would be a situation where even that it's 51%, it's sufficiently decentralized where it would not become a U.S. taxpayer. But it's one of these facts and circumstances issues that we need to sort of think through. But generally, you're right. If the trustees are not majority U.S., then we're going to be fine.
If the DAO were to use a Guernsey trust to expedite these kinds of legal functions, would you still see a long-term, you may have answered this earlier, but would you still see a long-term legal benefit to establishing a foundation somewhere else, even if a trust were used? I think one big question that still lingers in the community is seeing these more prominent projects like Ethereum, Solana, even DYDX, which already has Guernsey trusts. Those projects also have foundations. And so I think the community wants to make sure that, even if we do go the trust route, that we're not missing out on something by not having a foundation.
It's a good question. And my only answer, my answer, which is maybe not the perfect answer, which is I think a lot of people have done that from sort of a lemmings perspective. And I think it's somewhat of a marketing thing over a legal thing. Because from a legal aspect, I'm not seeing a true benefit to going to Cayman or Switzerland if we have other options, and whether that other option be, Guernsey or Panama. I think it's more of a marketing thing because the top projects probably end up going to Switzerland because it's the most expensive and the most quote unquote prominent. So the next tier go to Cayman, and then the last go to Panama. And that's not fair because a lot of people go to Panama who are top projects. But, there's a lot of just marketing aspect to it. And I have yet to find a persuasive legal argument as to why anybody needs a Cayman or a Swiss foundation to set up a DAO. And I could be wrong in that regard, but I haven't been persuaded one way or another. Those foundation structures are the be all end all, and everyone needs to have them. I think people started doing it in 2017, and it's sort of been lemmings, right? They did it, we're going to do it. We want to look like how they did. If we want to attract investment, we've got to look like how they did, or they do.
So it's more so reputation based as opposed to legal based.
That's where I am on it. Again, I haven't, and I'm sure you get some people who disagree with that, but I have not heard a persuasive legal argument as to why you need a foundation. The way I see it, it's all about sort of marketing reputation. But some of that is like, do the actual users care whether it's a Swiss, Cayman, Panama, or special purpose trust? Does a trader on DYDX give a shit? Probably not. So yeah, to me, it's like a sort of a marketing game, if you will, mixed with lemmings, really.
So in the AMA channel, one of our community members, RV, asked if you know anything about the Marshall Islands and if there are any benefits of setting up there.
I'm not super familiar with the Marshall Islands. I know a close colleague has looked at it, but felt that Panama was a better option. I could get back to you on that and understand exactly why that was the case. I respect this lady. She's represents a bunch of top projects, but I don't have that knowledge off the top of my head. Yeah. So I'm not seeing any benefit setting up there. Yeah, it's a new thing. Yeah.
And just to reiterate, in case you and I haven't covered anything on this call that, and we're actually, I'll start inviting people up now, but in case we haven't covered anything that the community wants to know more about, the community has an option to fund a more comprehensive report from you or 1121 on pros and cons of different jurisdictions in the context of these kinds of considerations. So again, this call is not meant to be comprehensive. It's just meant to give a high-level overview to cover the bases.
Yeah, I think that's right. That's what we talked about last time. And I hate to do this, but I do have a hard stop at the end of the hour. I apologize. I should have set that out the outright. I'm happy to sort of answer any questions on the AMA moving forward. And if someone wants to chat, do so. It just sort of...
Let's start bringing people up.
Yeah, absolutely.
Let's squeeze them in the next 5 minutes. So if anyone has any questions, feel free to raise your hand. And I'll invite you up. Okay.
Yes, can you hear me?
Yep.
Great. So, Mark, I'm actually a colleague. I'm a lawyer, but EU based, and I'm a law professor. I'm also founder of the Blockchain Lawyers Group. I was invited here. I was a holder of RAN a lot of time ago, but I was invited here from a member of the community. And I wanted to share a bit my impressions because I'm an enforcer of a Guernsey trust for a big layer one. I cannot say the name, but
sure.
I wanted to tell you which are the advantages and the disadvantages of having this kind of structure. First of all, I want to say that it is a contract, so it's a very comprehensive contract in which you can basically indicate exactly what the trust can do and what the trustees can do and what the trustees cannot do. And so it's strictly related to the governance mechanism that you have on chain. And I would say that the situation in which the trustee does something which is not aligned with the community, in my opinion, it's very difficult to have because everything is controlled on chain. You have a multisig and trustees are in the multisig. And they are, of course, doxed, and they are also chosen as reliable people, which are, let's say, people that have a reputation also in the outside world. And so it's difficult to think that there might be a problem of a trustee that takes the money and runs away. Said this, of course, criminal law is territorial, and so if the trustee located in a part of the world does a crime, then the court has jurisdiction on him. But I wanted also to say that, in my opinion, the trust is very good for certain purposes, especially if it has to disperse grants, and this is the case of the layer one, and hold IP. it is not so fantastic for day-to-day operations. I agree 100% with Mark. Like nobody knows like how much these structures retain, like protect from liability with respect to members. But I have to say that the difference between a foundation and a trust is that in the foundation, at least you have an entity, like you have a point that you can attack, and which is, let's say, a legal subject different than the contributors. And this, in my opinion, could be an advantage on the long run. And I think that this also explains why normally, like the trust goes together with another type of entity. The case of the YDX is interesting, but I think that it was more like a vehicle for the community in this case. Like all the people that worked for the YDX were, I think, shielded by companies that were kind of service providers for
Sure.
the DAO. And so like it was not, the goal was not like really to limit liability. It was more to say, hey, this is the structure for the community decides and the trust executes. And this is a bit my opinion. Then with respect to the foundations, like the difference between Switzerland and Cayman, and an additional one that I've seen in the last two years, is that of course there are always like advantages and disadvantages. In Switzerland, you can have banking account. It's a better jurisdiction for reputation. So also like if the
Yeah.
foundation wants to do stuff, enter into agreements, it's more like the reputation is better. It can have easily banking, whereas it's very difficult in Cayman. But the problem is that there is like a governmental oversight. Like the foundation is controlled. It means if I want to pay David 1 million per year because he's the best contributor of REN, like I have a municipality that tells me no, you can't do it because it's something which has a public oversight which is constant over the years. Whereas these other foundations, these private foundations of Panama and Cayman, like they are completely private. And so, of course, if you do unlawful stuff, then you go to jail or you get convicted. But nobody tells you how you can spend your money. And I think this is a good advantage because you might have some flexibility in your operations, given that we are doing Web3. Finally, I want something from the like at the beginning, David, you've mentioned the need also to have an entity which issue the tokens. In my opinion, it's very important to have like two different kinds of entities. One structure that issue the token, and
Eagle,
another
sorry to have to cut
which,
you off, but out of respect for Mark, he does have a hard stop at 2 o'clock, so I want to give him a chance to respond.
I mean,
sure.
I'm agreeing with all this. I don't think there's anything that I'm disagreeing with, and I think you put some finer points on stuff here. So I appreciate that. Yeah, I mean, the issue of dropping some sort of token issuing sub, and then having sort of the foundation not actually be the token issuer is something that a lot of people have done, and I think that's what you were getting to now. I do have to run on my end, but feel free to continue to talk, right? I mean, I think I don't have all the answers or hold all the cards in this regard, so feel free if you have sort of questions moving forward to drop them in the Rosac AMA. I'll do my best to respond, and then we can sort of take things from there.
Yes, I had like two more minor points, and then we can of course discuss. I'm super happy, and I want also to say that I agreed with all the things that you said, but just like 2 points for clarification, also for the people that are listening.
I just want to thank him for being here because he has to run. Mark, thank you so much. This has been
pleasure. It was my pleasure for sure. Absolutely. We will, again, hit me up in the AMA chat if you need to. And Eagle, I appreciate you coming in and putting some finer points on this stuff. And sorry to have to cut it here, but yeah, it was a pleasure.
Problem, Mark. I've also added you on LinkedIn, like with my real profile. But
I think we have some. I'm sure we know the same people. If it's the Blockchain Lawyers Forum, and Ross, I used to work with him. So yeah, it's always good to connect with other folks in the space. So I appreciate that.
Great.
Thank you very much.
Thanks so much.
Sorry, Eagle.
So David, just tell me if you want. I go on. Otherwise, we close it here. It's not that I want to take your time, but I wanted to.
I just wanted to give Mark a chance to speak before he had to run. But yeah, definitely happy to stick around.
Yes, I wanted to tell you like just two more things that perhaps were not like 100% clear. Like, first of all, as I've said, normally the issuance of the tokens, if you plan to issue other tokens, it is done by another company that then gives a part of the allocation to another entity that holds the treasury. And so you create basically a structure which is just the structure that issues the tokens in a jurisdiction which is friendly, that does not undergo particular restrictions with respect to issuance. And this is something which is common practice, like you do it in offshore jurisdictions where you don't have any oversight, and you don't do like a public offering, you do it through transfers towards service providers or the structure that holds the DAO. It's something which works quite smoothly and it's not problematic. And the other point that I wanted to clarify is that, like, normally you've heard about all these foundations and trusts, but for the day-to-day operations, normally all these structures have also companies. Like, you have to imagine that there is a foundation on top, and then you have a company which is 100% owned by the foundation, and this company enters into contract with other players. And this is good because, like, in having this structure, basically the company does not belong to nobody, because the foundation, if you adopt Panama or Cayman, is completely ownerless. It's like a patrimony which has a given goal, and you put the companies underneath the foundation, and in this way you can fulfill like day-to-day operations, and it works smoothly. Like, if you take, for instance, Lido, it's more it's a partnership, it's not a foundation. But if you take, for instance, Ethereum named services, you've heard about the foundation, the Cayman Foundation. You can go to read. It's also interesting because you see like how the articles of association are coordinated with the DAO governance. But you have to imagine that then there is like a company that pays the salaries of the contributors, and that belongs to the foundation. And so basically there is a money flow which goes from the foundation to the company, because the company does some services for the foundation. And I don't want to, like, it's not so complicated in the sense that you can follow models that already exist. You can then choose how much companies basically to build, which one is better, depending also on the core contributors that want to engage in this kind of structures. And for instance, we've talked about the US people, and it's always problematic to engage them into this kind of structures if they are US residents. And also in my case, for instance, the trust in Guernsey, like, one of the requirements was not being a US person. And so, like, depending on the people, you can basically decide what to do. And I also wanted to say that, like, the nominee directors that were mentioned before by Mark, normally these are really super professionals of law firms on Cayman and on on Panama. And I'm really not aware about cases in which basically they behave in a way which is not aligned with the dispositions. Plus, they normally, as Mark was saying, don't have the control of the on-chain treasury. So what happens is that you have a director for entering into contracts and off-chain operations, but all the money transfers are made by the treasury, as it is right now, I guess. And so this is also something that you have to bear in mind. Last element: consider the need of having a banking account. In my opinion, it's not so important but it could be an issue. Like, if you want a banking account, absolutely, then you have also to think about a structure that gives you the possibility of easily having one. That's it. Thank you.
Thank you, Eagle. I think a bank account is a major consideration if you consider the way that we plan to issue the first couple of grants to the development team. So, the community voted to mint about 180 million new tokens, but instead of issuing those tokens directly to contributors, I think one of the plans was to raise capital using those tokens, subject to long-term vesting and a cliff. And so we would then put that cash in a bank account, unless it's USDC, that could potentially be an option. But it seems like that would be a consideration for whatever legal entity we do end up choosing. Would you consider that to be an issue with a Guernsey trust, finding a bank account that could
So
that would
just like normally, what happens is that these entities do not have a banking account. Like you've mentioned before, the devs that will work on the implementation of the new protocol, they normally are onshore, and basically you create a contractual relationship between the entity that represents the DAO, so to say, and the onshore entity. You have a contract. You demonstrate that you have two different legal subjects and that the devs do something in favor of the protocol, and they are paid in tokens, which the entity has. And then basically the tokens are converted and managed by the devs, by the entity of the devs. Because it's very difficult to have a banking account. So I remember I spoke with because it's a constant question. For instance, in Cayman, it was like 15 out of 100 got a banking account, and it was like an enormous fight because you need to undergo a lot of AML scrutiny. It costs a lot, so it depends also. Like they ask you directly for 500K in order so that it is convenient for them that take a bit of risk with a company which is related to crypto. For instance, in our case, and I can tell you, it's an important layer one. Like no way, like they have the foundation with the banking account, but the trust was something which should work only on chain. And in my view, it would be problematic to have a banking account.
So it seems like a way to mitigate that risk is to just work with stablecoins, even if you are raising outside capital, to just have dealings with USDC. That would also seem to mitigate the risk of a rogue trustee exercising unilateral control over a bank account, because bank accounts in TradFi don't work like multi-sigs.
Yes, this is important. And consider also, for instance, I'm the enforcer of this trust, and so I check the on-chain activity, and I'm also in the multi-sig. Like I don't vote, like I only look what they do. And so like it's something which you can better control. And in the case in which they misbehave but it never happened, like the community can vote them out, and there is like a control. You can also limit the risk in giving only the possibility of making small transactions. Like there are ways of mitigating this risk, which in my opinion is not enormous, because like when you choose your trustees, you can choose also 2 or 3, so that not only one has the entire power. And I mean, you choose among like people that are really reliable, and so it does not change so much in the kind of operation that you have now.
If anyone has other questions, you're welcome to come up. And I'm not sure that I can answer them. I think they'd be more for Eagle at this point. Men in Blast, are you there? I don't think we can hear you. Gonna go to, so Eagle, while we have you up here, let me just ask you, what would you advise the RenDAO to do?
I frankly would create a Panama Foundation with an operational company which belongs to the Panama Foundation, that is ownerless. And then, like, if you have some core contributors, they should wrap into a company that becomes a kind of lab. Because as far as I understood, like Rand Lab is not, at the moment, it's not a company. It's just like a group of people that work together. Or is there a company?
There is a company. I can't speak to.
No problem. Okay.
I'm not on Red Lab, so I can't speak on their behalf.
No, but it's not absolutely no problem. But the idea is that you have basically a representation of the DAO on chain, which is this foundation. This foundation, through the operational company, can enter into contracts, into agreements, and plus also pay contributors. And this is easily achievable. The trust, in my opinion, is more problematic in many jurisdictions. It is not recognized as a company. And I really want to understand that you understand that, like, the Guernsey Trust is a contract. Yeah, you don't have filings, you don't have registration. It's really something which exists, but it's really hard to think that it could wrap in the perspective of all the countries of the world. With respect to the foundation, it's unknown. So I agree with what Mark was saying. But it's a fact that, like, the problems that we are having with DAOs right now, we have two cases, one against Compound and the other one against Oki DAO. Like, the problem was that they were US based without an entity. And I think that at least if you have an entity, the normal thing to do would be to sue the entity instead, like, of looking for people that are anonymous. Like in the case of Oki DAO, they basically tried to bring in front of the court the DAO through a forum post, which was really crazy and didn't work. But I think that the fact that we don't have cases concerning foundation is a good example. Whereas the trust is a mechanism which is really a niche. Like, you have, I think that like, trust compared to foundations, I would say that we have structures with a trust in 3% of the cases, perhaps also less. Like, the foundation is the standard. And like, you can do also a bit of benchmarking and looking to the other DeFi protocols. There are protocols that choose the Cayman. Recently, Sushi chose the Panama. And then it depends a bit also on how much you can spend, because there is a huge difference. Like, if you go to Switzerland, it costs you like 40,000 francs, plus also all the costs related to the maintenance over the years. Panama is a very cheap jurisdiction, so you can do everything with Panama lawyers with a sum which is less than $10,000 for sure. A Cayman is something in between. It depends which lawyer you pick. It can be like from, I would say, 15 to 25, but the nominee costs much more than a Panama nominee. And so I would say that the standard is a bit like Panama, with a company who does the operation that can be a Panama Limited or a BVI Limited, which is owned by the Panama Foundation. This is quite common. But it works only on chain. Like, it will not have a banking account.
And would you agree with Mark that there is less of a clear legal benefit to going to a more expensive, costly place like a jurisdiction like Switzerland or Cayman, and those jurisdictions may be used more for,
So,
as Mark said, marketing, or in more of a reputational capacity than having a clear legal benefit?
So I agree on the fact that there isn't a clear legal benefit in the sense that Panama is completely unregulated. Cayman has regulations for AML and VASPs, but you would not enter under VASPs. Whereas Switzerland is a regulated country, and so people sometimes feel also safer. Like, if you plan to raise money from institutional investors, then being in Switzerland gives you the advantage that you are in a regulated country in which you can also have a legal protection, which is better. And so this is why they go to Switzerland. Although I have to say that they were very good, like in selling themselves from the very beginning of the crypto era. Between Cayman and Panama, I think that, like, Cayman is the favorite one because it's a common law jurisdiction and people are used to speak in English. And of course, if they are Americans, they are more inclined to speak in English. In Panama, you find very good lawyers, but the documents are in Spanish. So this is something which not everyone wants to tackle. And there are translations, of course, but the official documents are in Spanish. And so like it's not really a common law jurisdiction. It's a jurisdiction that has some peculiarities which make this jurisdiction closer to the United States, to England, whereas BVI speaks the same language as England and the United States broadly. And so I think that this is why like people prefer Cayman. Plus there are 2, 3 very good law firms like that you can rely on because they work like with global law firms all over the world. And so people feel more protected because these law firms have a big name. But of course, it depends on the size of your project, and like I wouldn't say that there is a huge difference between the three. Like for contributors that are in Western legal systems, having to do with a Swiss foundation is better than having to do with a Cayman foundation because there is always like this tax problem and having direct relationships with these entities. But I think that if there is like a clear division between the contributor side and the entity side, which holds the protocol, then it's not an issue. You simply pay your taxes in your jurisdiction and you get the money from the central entity. And so, yes, I hope this responds a bit to your question. I think that in the last years, like people began to think that Cayman is better than Switzerland because Switzerland is very expensive and you have this external control over your expenditures. And this is something which is blocking also heavily the Ethereum Foundation. They are absolutely not happy about the way in which they can spend their money because of the fact that they have always to justify in front of the authority what they're doing. And this is an element which is unexistent in Panama and in Cayman. I would say that Panama is a bit the underdog compared to Cayman, but there are very good lawyers. Like if you, like, and I also wanted to say because like I'm Italian, I'm Central Europe, but I have this association of blockchain lawyers. We are 65, also with US lawyers. We have 2 very good Panama lawyers. We have a Swiss lawyer, and so if you're interested really in having a comparison between these models, we can organize a session with all of them. It would be also interesting for us. I'm really happy to do it. Like I bring you the Swiss, the Panama, and also the Cayman lawyer, and you can compare them and see what basically they tell you. Finding a Guernsey lawyer is a bit more difficult because normally they work from the UK, but I can ask if there is a UK person that wants to speak.
Inviting Freddie up to the stage. Freddie? You're muted in case you're talking.
Perhaps he has some micro issues.
Yep. So, Eagle, one question about a foundation in either Panama, Cayman, or Switzerland. How would you go about appointing board members or council members to these foundations? Should these people should they come from within the Ren community, or potentially more reputable or trusted people from the broader ecosystem that could be trusted to act in Ren's interests? How would you think about that?
Yes, I think that there isn't like a direct answer. It depends on the type of contributors that you have. Like my first point is that the contributors should not risk anything when they take these positions. If the community feel that they are reliable and they don't encounter legal risks, and there are cases, for instance, in Lido, like I have one of the directors I cannot tell you more, but imagine one of the directors lives in Italy. We made an assessment in Italy, no risks, and she is the director of a BVI company. And this holds true like for every community. There are people that are not affected by particular legal risks because, for instance, they are resident in Dubai. This is like a classic in DeFi. And in Dubai, you don't have disclosures concerning holdings or roles in entities which are offshore. And therefore, like there are a lot of people that are inclined to take the risks and get paid for it. And I think that if there are within the community, it is better to put the people from the community on the board if you have this type of people. Otherwise, as I've said, you go with the nominee. You go with the nominee, and it is something which, of course, protects your privacy because nobody knows who is behind this entity because they are completely ownerless. Like there's only a person that you have to indicate, which is called protector. Is basically a person that behind the scenes should take care about the fulfillment of the goal from a legal point of view. It's a bit like the enforcer in the trust. But apart from this, if you put the nominees, like nobody knows who is behind this entity, and it's quite normal to put the nominees. And you can have nominees for the foundation and also for the companies that are owned by the foundation. So I think that it is something that you have to understand within your community. If there are people that want to step out, that are known from the community, reliable, and they can then be part of the board, or you can also do it mixed. Like there are some people there is a nominee plus a person that belongs to the community, and yes, this is so it depends. Like my first point is not putting people in danger, like perhaps they're not entirely aware about their own situation in the legal system of provenience, and so they go for it without like taking into considerations all the implications. And then, of course, there is a risk of liability, but this can be mitigated through contractual agreements with the DAO community, in the sense that the person is then if it really encounters liability for something which is done in basically fulfilling the indications of the community, then you can also provide a kind of agreement that gives him the possibility to get a recovery in cases of loss. But like it really depends which is the function of the entity. I think that if it's just like an entity that deals with treasury management, and it's so an entity that does not really fulfill the aim of making profit, it's not so dangerous from a legal point of view. So I've never heard that there were problems concerning this type of like liability for this type of people so far. So just to finish, it's more a question related to the jurisdiction of provenience of the person that will be part of the board. For instance, in the US, I would avoid like to be member of a board, but perhaps, I don't know, we have a person that is resident of Thailandia, citizen of a different country, that wants to do it, has no fear, and therefore it would be suitable to have this role.
Hi, thank you, David. Sorry for my microphone issues before. I follow up the call since probably middle. I think that the best option is the Panama Foundation. I think it's faster, it's cheaper, and I think the regulation is better. You know, I understand the reputation, as Eagle was saying about Switzerland, but I think that it's not a good option because it's much more expensive, and you need to have a Swiss in the board. Like they are going to be in top of everything. So I don't think Switzerland is a good option. Cayman Island, I understand that it's a very good option because of the English language and the common law. I understand Spanish, that's my native language, so I could help with something in Spanish if that's the case. but I'm pretty sure that there are pretty good translations for all the standard documents already, because it's really, Panama is famous for this kind of offshore enterprises, foundations. If you want to make an offshore account for SA, you do go to Panama. Here in Latin America, Panama is the go-to place for all of this stuff. So I think that Panama, it will be a great option because it's faster. We need it to be fast. It's cheap, but also Cayman, I think it's a good option because of the common law and the English-speaking language. But it's not as fast as what I understood from Mark. And I have a question after this. I think that the liability, I think one of the core issues for example, for me, if I were to, help and be on some kind of association for the foundation or anyone that can be, what happens if one hacker uses their MVM, which is decentralized, to move ill-gotten funds? If you can be liable and you can be called to court and, for something like that, I think that's one of the main concerning points for me or for anyone that will be participating in the foundation.
Okay, so you're basically asking, is it a danger for the director if there is a hacking which affects the protocol?
No, not hacking that affects the protocol, but yeah, that's a good question as well. But I mean, if a hacker that has ill-gotten funds uses RMBM to move them from one network to another network, or to burn them back to Bitcoin or Ethereum, I don't know. Yeah, that kind of situation in which they can use the protocol because it's decentralized, but because it has a foundation, it has an legal entity, if they can hold accountable the directors or the members of the foundation.
Yes, so I would say no, because the way in which I would frame it is that basically the foundation is just something which coordinates a bit the efforts of the community. So it's not really like the holder of the protocol. I would leave the protocol as completely decentralized, as something which, for instance, we have in the case of Balancer, of Aave. This is pretty common. Like the protocol is there with the smart contracts that were developed, but like the foundation is not responsible for what the smart contracts do and for possible exploitment. And in this way, like you create a structure in which the foundation is a vehicle for the coordination of the community and also like for fulfilling some tasks. For instance, if you have a foundation and a company which is owned by the foundation, you can indicate that the front end is held by this company, and you can enter into agreements enter into partnerships, but it's not the owner of the smart contracts, and this is made clear like in terms and conditions that you basically put down when you have a legal entity on your front end. And so I would say that in this case it's very difficult that there could be an issue for the management. But of course, as I've said, like a lot of DeFi projects choose to have a nominee director, and also like consider that. Now I don't know you, Frido, but normally you go against a person towards which you can actually get a recovery. And like normally a director is not a person that has the means. Like imagine that we have a hacking of 80 millions. Like even if you go against a normal person, there's no way that you can recover the money. And so I would not say that this person is particularly in danger for this type of situations. But in any case, as I've said before, like you try to distinguish the spheres and indicate that the operations of the smart contracts are completely autonomous from the management tasks of the foundation. And then, of course, there are some also other issues you see. Now, I don't know very well the functioning. I have also to look into REN 2.0. But like, for instance, smart contracts, if they are immutable, it's better. If there isn't like a management behind the smart contracts, or if there isn't a possibility to update or upgrade the smart contracts, it's better because like you can strengthen this narrative that the smart contracts are there as a kind of public good and that nobody is really responsible for them. But of course, it's something which then we have to assess from a technical point of view. In any case, like as you were saying, in Panama, for instance, I know two very good, and especially a woman who is fantastic and speaks really an incredible English, and also for the documents, it's not an issue today to have proper translation. So I agree with you that that's not an issue. Then, of course, happy to have a Spanish hermano, but or a Spanish-speaking hermano at least. But yes, it's not an issue. Absolutely.
Okay. Yeah. Thank you. It makes sense. Thank you.
Hello, hi, can you hear me? Hi, Igor. I have a question. So in terms for the next steps, what would be your recommendations in terms for us, how to organize ourselves, in a way that we can proceed with whatever structure we decide? So for example, would it be recommended to maybe create a group, and that group is the one that engages to the lawyers and go through the whole system, or should we already decide on board members and all those sort of positions at this point in time? I'm just trying to think from the operational side how we're gonna move forward and what should be sort of like the path that we need to do, because obviously a big community with many people, with different opinions. I think we need to sort of reduce the number of actors, and then from there move forward once we decided which structure we want to go.
Yes, totally. Like I'm seeing a bit also what is happening in the space. Like you're not the first case that basically after a long ride without an entity is now setting up an entity structure. For instance, I was studying like 2 days ago AMX on Arbitrum. They now decided to set up an entity in September. Like normally what happens is that there is a forum proposal which already sets a bit like what you want to do, and so basically you create a soft consensus within Discord and within the group of core contributors, and then you propose something which is not like 100% detailed but nonetheless gives a bit the structure. It happened also in the case of sushi, and then you propose it to the forum, and this goes then in the direction of choosing the lawyer. And so basically, I think that there must be some, let's say, groundwork which is done before by the core contributors that meet the lawyer, that get basically all the elements that needs to be decided, which are not so huge. So in the case of Panama Foundation, it's really like the board of 3 people with the protector, and so deciding if you want to have nominee or if you want to have like persons that are part of the community, and then you choose the name, of course, which I really think that it's better not to give the same name of the protocol, because you want to show that it's not really the protocol. It's like something which works in the interest of the protocol. And yes, that's it. So I think you need to find a soft consensus within the community. What I can do on my side is bringing you the Panama lawyers if there is a willingness to go in this direction. But as I've said, I can also bring you a lawyer that made Guernsey trusts. For instance, in the layer 1 case that I was addressing before, it's like an American lawyer who is very known. And I can ask him if he wants to show up. I mean, you're an important community, and there is the willingness of the crypto lawyers to indicate also which are like the best ways of solving issues, although not everything is clear. And so it's up to you. I think you have to test a bit which is the kind of consensus that you have on issues in addressing all the different opportunities. I think that at this stage, like a Swiss foundation would be probably too much. Like you do this if you want to raise lots of money, but your project is an ongoing project, and so I don't see so much the need. And then it's true that you need a Swiss resident. As a little gift, I've left on the Discord the foundation deed of Ethereum, of the Ethereum foundations. I think it's an interesting document because you can see that basically it's very simple without so many provisions. You see the signature of Vitalik together with some random Swiss guys, which were the other board members of the foundation, who had to be Swiss, of course. And you don't have this problem of hiring a Swiss person who is super expensive, who does not know or of course, if you have a Swiss in the community, then it's fine, but usually it's not the case. And so it's up to you. What I can do is like put you in the best position to decide. And if you want a direct contact to these lawyers that act exactly in the jurisdictions for which you're interested, I can bring you some. Because of course, like every crypto lawyer, as Mark and me, we have experience a bit in this global crypto context. But if you speak with a native lawyer of the jurisdiction, I think it's much better to address the issues that you want to understand and solve.
Perfect. Thank you.
Does anyone have any more questions? So, Eagle, I'll go out on a limb here on the community's behalf and say that we would probably be interested in speaking with a lawyer in Panama. There seems to be consensus from you and Mark that a Panama foundation would be favorable. Just by virtue of that, I think it'd be worth having a conversation with someone down there to see what next steps could be and whether it'd be in the best interest of the protocol.
Okay, very good. So I can bring them into the Discord if you want, into the foundation setup, and then I don't know if you want to organize another meeting also with Mark. And like the two lawyers that I bring you are really crypto lawyers, so it's not like the super big law firm. And then you decide like if you trust them, but they're quite known and very knowledgeable and kind. So I think it will be a fine meeting.
We would be very grateful for that. Thank you.
Absolutely.
And thank you so much for jumping on as well.
You're welcome. I'm really happy. Like, as I've said, I was invited by this close friend, but I knew, of course, the project, and I'm really happy to help. Like, every project has its own peculiarities and problems, but I really love the space, and I'm super happy like to engage in these ways and putting also people together. And trying also to solve this issue and look in the right direction. I know that you were affected by this cows, and but I'm happy to see that you have important plans to overcome these problems. And yes, you're a strong community, not a new one, and I'm sure that you're going to overcome and become even stronger.
Well, thank you again. We'll see you in the governance channels. And if no one has any other questions, I guess we'll call it there.
Okay, great. Fantastic. Have a nice day, afternoon, and night, wherever you are. Bye-bye.
Thanks, Eagle, and thanks everyone else for joining.